If you are a green card holder living in the United States, stop everything for a moment, because something shocking has just been officially approved. A brand new U.S. immigration law for 2026 has passed, and it changes the rules for permanent residents in ways most people never expected. This is not speculation. This is not political rumor. This is real legislation that will directly affect millions of green card holders starting very soon. Under this new law, your travel history, your taxes, your employment, the benefits you receive, and even old legal issues could now determine whether you keep your permanent resident status. For the first time in decades, green card holders will face mandatory government reporting, stricter presence requirements, and expanded enforcement that could put many people at risk without them even realizing it. And here is the most alarming part. Some of these changes apply retroactively, meaning actions you took years ago could suddenly be used against you. Many permanent residents right now have no idea what is coming, and that lack of knowledge could have life-changing consequences. So the big question is this: what exactly has changed, and how does it affect you and your family? In this video, you're going to get a clear, simple, step-by-step breakdown of the new law, what it requires, what it restricts, and most importantly, what you need to do right now to protect yourself. Stay with me because by the end of this, you will know exactly where you stand and how to stay safe under these new rules. Hi, I'm Timothy, and I'm here to help you understand what's really happening with U.S. immigration in plain, straightforward language. I know how confusing and stressful immigration news can be, especially when laws change this dramatically. That's why today we're going to slow everything down and walk through this together so you don't feel overwhelmed or left in the dark. The law I'm about to explain is one of the biggest shifts in immigration policy in modern history, and it impacts almost every single green card holder in America. Whether you've had your green card for 1 year or 20 years, whether you travel often or never leave the country, whether you plan to apply for citizenship or not, these changes still apply to you. My goal is to break this down clearly so you understand not just what the law says, but what it actually means for your everyday life. Over the next several minutes, I'm going to explain the 8 major changes this new law introduces, who is most at risk, and the exact steps you should be taking starting today. Some parts of this may sound worrying, but knowledge is power, and being informed is the best way to protect yourself and your future. So, take a deep breath, stay with me, and let's go through this carefully, one piece at a time. Let's begin with the foundation. What exactly has been approved? After months of debate and negotiation, Congress has officially passed and the President has signed a sweeping new immigration law that dramatically reshapes the responsibilities of lawful permanent residents. This law, set to take effect in 2026, represents the biggest overhaul of green card regulations in more than 30 years. Lawmakers say the goal is to make sure permanent residents are truly living in the United States, contributing to society, and working towards citizenship. But behind those simple explanations are rules that are far stricter, far more detailed, and far more aggressive than anything we've seen before. What used to be a relatively stable and predictable status holding a green card will now come with ongoing obligations, regular government monitoring, and new risks that never existed in the past. Many green card holders have lived comfortably for years, believing that as long as they avoided serious legal trouble, their status was secure. This new law changes that assumption completely. It creates new standards for travel, employment, taxes, benefits, criminal history, and even personal conduct. And most importantly, it gives immigration authorities much stronger tools to review, question, and even revoke permanent resident status. Over the next few minutes, I'm going to walk you through the most important changes, one by one, so you understand exactly what this means in real life. Some of these updates are straightforward, others are complicated and a little unsettling. But by breaking them down clearly, you'll be able to see how they apply to your own situation. The very first major change, and possibly the most significant, is the introduction of mandatory reporting for every single green card holder. Starting in 2027, all permanent residents will be required to file a formal status report with USCIS every 2 years. This has never existed before. Right now, green card holders only need to notify the government if they change their address. Under the new system, that minimal requirement disappears. Instead, you will have to regularly submit detailed information about your life to immigration authorities. These reports will include your current address, your employment information, confirmation that you have filed taxes, details about any criminal history, records of time spent outside the United States, and even information about your immediate family members. In other words, the government will now expect ongoing proof that you are truly living as a permanent resident should. The entire process will be handled through a new online portal, and each report will need to be filed within a specific time window assigned to you. If you miss that window, submit incomplete information, or make mistakes, it could trigger serious consequences. USCIS will review every report, and if they believe something is wrong, they can begin proceedings that put your green card at risk. Even longtime residents who have lived quietly and responsibly for decades will have to comply with this new system. There are no exceptions based on age, length of residence, or personal circumstances. Whether you received your green card last year or in the 1990s, this requirement applies to you. This change alone represents a massive shift in how the United States treats permanent residents. Instead of simply holding a card and living your life, you will now be expected to actively prove your eligibility over and over again. Many people are going to find this stressful, confusing, and intimidating, especially those who are not comfortable with online systems or government paperwork. There will also be a filing fee for each report, currently proposed at $75, which adds an ongoing financial burden that never existed before. USCIS says fee waivers will be available for low-income individuals, but that still requires extra forms, extra documentation, and extra approval. And here's something very important to understand. Failure to file these reports on time is not treated as a small administrative mistake. Under the new law, it can be considered a violation serious enough to start removal proceedings. That means simply forgetting, misunderstanding, or overlooking a deadline could potentially put your entire future in jeopardy. For millions of green card holders who are used to a hands-off system, this new reality will require a completely different level of organization and awareness. So already with just this first change, you can see how different the landscape is about to become. The days of receiving a green card and then rarely interacting with immigration authorities are coming to an end. From 2026 forward, permanent residence will involve active participation, regular documentation, and constant compliance. And this is only the beginning. The reporting requirement is just one piece of a much larger transformation that also affects how long you can travel, what benefits you can receive, and how your past actions are judged. In a moment, we're going to talk about the next major change, new physical presence rules that could completely reshape how often green card holders are allowed to leave the United States. And for frequent travelers, business professionals, and families with ties abroad, this next section may be even more important than the reporting system. So keep listening because what comes next could directly affect your ability to keep your status. The second major change introduced by this new law focuses on physical presence inside the United States. And this is where many green card holders are going to feel the impact immediately. For years, the rules about travel and time spent outside the country were somewhat flexible and often open to interpretation. People understood that staying abroad too long could cause problems, but the exact limits were not always clear. That flexibility is now disappearing. The 2026 law creates strict measurable standards for how much time a permanent resident must physically spend inside the United States in order to keep their status. Under the new rules, if you are outside the country for more than 6 months in any 12-month period without special permission, the government will presume that you may have abandoned your residence. If you are outside the country for more than 1 full year, abandonment of your green card will be automatically presumed, and the burden will fall on you to prove that you never intended to give up your U.S. residence. That is already a much tougher standard than what existed before. But the law goes even further by introducing cumulative presence requirements. To maintain your green card, you must now be physically present in the United States for at least 6 months out of every 12-month period. And over a 5-year span, you must have spent at least 4 full years inside the country. Falling below these thresholds can put your permanent resident status at risk. This change is especially serious for people who travel frequently for work, who care for family members overseas, or who split their time between the US and another country. In the past, many green card holders managed their lives across borders without major issues. Under the new system, that lifestyle becomes much more dangerous. Simply preferring to live part-time in another country or spending long periods with relatives abroad will no longer be acceptable reasons for extended absences. Only very specific circumstances, such as working abroad for a U.S. company, serving in the military, or dealing with serious documented medical emergencies, will be considered valid exceptions. Even then, you will need strong proof and official permission to protect your status. A re-entry permit may help in some cases, but even that does not fully excuse you from meeting the overall physical presence requirements. The message from this law is very clear. Permanent residence now truly means permanent physical residence in the United States. If your life currently involves frequent international travel, long stays overseas, or extended family obligations outside the country, you will need to rethink your plans very carefully. Many people who never imagined having immigration problems could suddenly find themselves at risk simply because of how they have been living for years. The third major change is one of the most controversial parts of the entire law, and it involves public benefits and something called public charge. For a long time, there have been rules limiting when immigrants can receive certain government assistance. But this new law dramatically expands those restrictions for green card holders who are already living in the United States. Under the 2026 law, if a permanent resident receives specific public benefits for more than 12 cumulative months, their status can be reviewed and potentially revoked. The benefits included in this calculation are programs like SNAP food assistance, Medicaid except for emergency services, supplemental security income, cash welfare assistance, and federally subsidized housing. If USCIS determines that you have relied on these benefits for too long, they can begin proceedings to take away your green card unless you can prove that your financial situation has changed and that you are no longer likely to depend on government support. What makes this provision so shocking is that it can affect people retroactively. Many green card holders legally used public benefits they were fully entitled to, especially during difficult periods like the pandemic, job losses, or medical emergencies. At the time, there was no reason to believe that accepting help would ever threaten their immigration status. Now, under this new law, those past decisions could suddenly be used against them. Elderly permanent residents who rely on Medicaid or SSI are particularly vulnerable, as are low-income families who received food or housing assistance during hard times. Immigration advocates argue that this change is deeply unfair because it punishes people for following the rules that existed at the time. Supporters of the law claim it encourages self-sufficiency and protects public resources. Regardless of where you stand politically, the reality is that this provision creates serious new risks for millions of lawful residents. For many green card holders, this change will force extremely difficult choices. Some people may feel pressured to avoid seeking medical care or financial assistance, even when they truly need it out of fear that it could cost them their status in the future. Others may suddenly need to look for ways to become financially independent much sooner than they planned. Families who have relied on public programs for years will now have to reconsider their options and possibly seek legal guidance to understand how exposed they are. This part of the law sends a powerful signal that permanent residence is no longer just about living legally in the United States. It is now also about proving that you can support yourself without government help. And for vulnerable populations, especially older immigrants and those with limited income, that is a very heavy burden to carry. These first three changes alone, mandatory reporting, strict travel limits, and new public benefits rules, completely reshape what it means to be a green card holder in America. But the law does not stop there. In fact, the next set of changes may be even more alarming for many people because they involve employment expectations, tax compliance, and how the government measures your overall economic contribution. In the next section, we're going to talk about how this law creates new financial and work requirements that every permanent resident must now meet and what happens if you fall short. The fourth major change introduced by this law centers on employment, financial responsibility, and economic self-sufficiency. For the first time, permanent residents will be judged not only on whether they live in the United States, but also on whether they are actively contributing to the economy. Under the new rules, green card holders between the ages of 18 and 65 are expected to be working, studying, or otherwise financially self-supporting. If a permanent resident goes for more than 18 months within any 3-year period without employment or formal education, immigration authorities can review their status and question whether they still qualify to remain in the country. In simple terms, the government is now saying that holding a green card is not just about legal residence. It is also about demonstrating ongoing productivity and independence. There are some exceptions written into the law. People who are disabled, those who serve as full-time caregivers for family members, and individuals facing serious documented barriers to employment may be able to avoid penalties, but the burden will be on the green card holder to prove that they qualify for those exceptions. That means gathering paperwork, medical records, letters from employers, or other evidence to show why they were not working. For many people, especially older immigrants or those in unstable job markets, this requirement will add a new layer of stress and uncertainty. Along with employment expectations, the law also brings much stricter enforcement of tax obligations. Technically, green card holders have always been required to file U.S. tax returns and report worldwide income, even if they lived abroad for part of the year. In reality, that rule was not always aggressively enforced. Many permanent residents fell behind on taxes or misunderstood their obligations without facing serious immigration consequences. Under the 2026 law, that leniency disappears. USCIS will now actively cross-check immigration records with the IRS. Every time you submit your mandatory biennial report, your tax history will be reviewed. Missing tax returns, unpaid taxes, or inconsistent reporting can now be used as evidence that you have failed to meet the responsibilities of permanent residents. In extreme cases, it can even become grounds for revoking a green card. This is a wake-up call for anyone who has ignored tax filings in the past. If you are a permanent resident and you have unfiled returns, this is no longer something you can postpone. Getting into compliance immediately is essential. The IRS does offer programs for people who need to catch up. And while there may be penalties or interest, fixing the problem now is far better than waiting until USCIS discovers it during a review. This part of the law makes it very clear that financial responsibility is now directly tied to immigration security. The fifth major change is perhaps the most frightening for many people because it involves criminal issues and moral character. Immigration law has always allowed certain serious crimes to affect green card status, but this new law dramatically expands what kinds of conduct can put a permanent resident at risk. In the past, only major offenses such as aggravated felonies or crimes of moral turpitude usually triggered deportation concerns. Now, the list has grown much longer and much stricter. Under the 2026 rules, even relatively minor offenses can create serious immigration problems. Multiple DUI convictions, domestic violence misdemeanors, drug possession charges, theft or fraud offenses, and crimes involving dishonesty can all become grounds for revoking a green card. What makes this even more alarming is that the law allows USCIS to consider conduct even if it did not lead to a traditional conviction. Cases that ended in probation, deferred adjudication, or expungement under state law can still be used against you in immigration proceedings. Many permanent residents who believe their past mistakes were behind them could suddenly find those issues resurfacing in a very dangerous way. The law also goes beyond formal criminal convictions and introduces something called conduct-based review. This means that even without being charged with a crime, a green card holder could face problems if immigration authorities believe they have engaged in behavior that shows a lack of good moral character. Allegations of fraud, tax evasion, misuse of benefits, or other dishonest actions can be enough to trigger an investigation. And unlike in criminal court, where guilt must be proven beyond a reasonable doubt, immigration cases operate under a much lower standard of proof. USCIS only needs to show that it is more likely than not that disqualifying conduct occurred. That makes it far easier for the government to take action against someone based on records, reports, or accusations that would never stand up in a criminal trial. For permanent residents with any kind of legal history, even something small from many years ago, This part of the law is extremely serious. It means that the margin for error has become much smaller, and the consequences for past mistakes have become much greater. All of this represents a fundamental shift in how permanent residents are evaluated. In the past, most people felt that as long as they avoided major trouble, paid their taxes, and lived quietly, their green card was safe. Under the new system, every part of a person's history, employment, finances, benefits, travel, and personal conduct can be examined and re-examined. The standards are higher, the scrutiny is stronger, and the room for forgiveness is much smaller. And these changes do not just affect individuals, they also reach deeply into family relationships and the path to citizenship, which is exactly what we're going to talk about next. In the following section, I'll explain how this law changes family-based green cards and adds new hurdles to becoming a U.S. citizen, two areas that millions of immigrants care about more than anything else. The sixth major change brought by this law reaches into an area that many people never expected: family relationships. A huge number of green card holders originally received their status through a family member such as a spouse, parent, child, or sibling. In the past, once the green card was granted, immigration authorities generally did not continue monitoring those relationships. The 2026 law changes that completely. Now, permanent residents who obtain their status through family sponsorship will be required to show that the relationship which formed the basis of their immigration remains genuine and ongoing, especially during the first 5 years after receiving the green card. For example, if you received your green card through marriage to a U.S. citizen, and that marriage ends in divorce or separation within 5 years, USCIS will automatically presume that the relationship may have been fraudulent. The burden will then fall on you to prove that the marriage was real and entered in good faith. That can require extensive documentation, interviews, and legal battles, even if the divorce had nothing to do with immigration at all. Similar rules apply to other family-based categories as well. If you received your green card through a parent, adult child, or sibling, and you later completely sever ties with that person, immigration authorities may question whether the original relationship was legitimate. The intention behind this rule is to prevent immigration fraud, but in reality, it also puts ordinary families under a level of scrutiny that feels intrusive and unfair. Relationships change, marriages fail, and families sometimes grow apart for completely normal reasons. Under this new system, those personal life events could suddenly have immigration consequences. Many people who believe that receiving a green card meant stability and security may now discover that their status can be questioned years later because of private family matters. This part of the law makes it clear that permanent residence is no longer viewed as truly permanent until many additional conditions are satisfied over time. The seventh major change affects something almost every green card holder dreams about: the path to U.S. citizenship. While the basic eligibility timelines remain the same, the process of naturalization is becoming significantly harder. You will still need to be a permanent resident for 5 years or 3 years if you obtained your green card through marriage to a U.S. citizen. But beyond that, new requirements have been added that make the journey much more demanding. First, you must have filed all of your required biennial reports and had them approved without serious issues. If you missed a report, filed late, or had problems during review, that could delay or even block your citizenship application. Second, you must meet the stricter physical presence standards created by the new law. Any long absences from the United States that violate those rules can now directly prevent you from qualifying for naturalization. The civics and English requirements are also being expanded. Applicants will face a more detailed civics examination with tougher questions about U.S. history, government, and civic responsibilities. English proficiency standards will be raised, requiring stronger speaking, reading, and writing skills than before. For many long-term residents who learned basic English years ago and never needed to improve further, this could become a serious challenge. But the most controversial addition is an entirely new requirement that applicants must demonstrate meaningful integration into American society. This means you may now be asked to prove involvement in your community through activities such as volunteering, membership in local organizations, participation in civic events, or other forms of social engagement. USCIS officers will have discretion to evaluate whether you appear truly integrated into American life, culture, and values. This requirement worries many advocates because it introduces a level of subjectivity that has never existed before. Integration can mean very different things depending on a person's background, culture, age, or personal circumstances. Some immigrants work long hours to support their families and simply do not have time for community activities. Others live in close-knit cultural communities where involvement may not look like traditional American civic participation. Yet, under the new law, these personal differences could affect a person's ability to become a citizen. The overall message is clear. Citizenship is no longer just about living in the United States for a certain number of years and passing a test. It is becoming a much more complex process that requires extensive documentation, stronger qualifications, and a longer track record of compliance. For many green card holders, this change alone may completely alter their plans. People who once assumed they could apply for citizenship whenever they felt ready may now feel pressure to apply sooner rather than later, before the new standards make the process even more difficult. Others who were already preparing to apply may need to gather far more evidence than they ever expected. The dream of becoming an American citizen is still very much possible, but the road to get there is about to become steeper and more complicated. And while all of these changes are important, there is still one more major piece of this law that ties everything together. The expansion of enforcement powers and the increased consequences for anyone who fails to meet the new requirements. That is what we're going to discuss next, because understanding how the government plans to enforce these rules is just as important as understanding the rules themselves. The eighth major change in this new law is all about enforcement, and this is where everything we have discussed so far becomes very real. For decades, most green card holders lived with the understanding that as long as they avoided serious trouble, immigration authorities were unlikely to interfere in their daily lives. The 2026 law flips that approach completely. It provides USCIS and ICE with significant new funding and expanded authority specifically aimed at monitoring permanent residents and enforcing these new requirements. That means more investigations, more audits of records, more interviews, and more removal proceedings than ever before. Instead of a system that mainly reacted to major violations, the government will now be actively searching for problems,